Court does call the cases of the People's State of Michigan versus Jeremy Shue.
This case opens in pure chaos, and the energy in the room is already tense before anyone even speaks. We're dealing with two separate preliminary examinations, multiple officers, incomplete medical records, and a defendant, Jeremy Shue, whose situation is already tangled before the hearing even begins. What you're about to see is a courtroom trying to untangle a mess created inside a jail cell, and Judge Simpson knows from second one that this is not going to be simple. Notice how even the prosecution cannot give a straight answer yet. There are 3 officers, but 2 belong to one case and 1 to the other, and sequestration becomes the first chess move of the day. Right here, the judge is setting the tone, controlled, procedural, but already bracing for conflict. This intro tells you exactly what kind of hearing this will be, one where facts, injuries, procedures, and conflicting interpretations collide. And it all starts with a broken rib, a hyperextended thumb, and an inmate who reportedly refused to comply with orders. You'll see how a simple tablet retrieval spirals into a full-force confrontation that leaves a deputy injured and a defendant facing serious charges. The stakes are high from the very first moments.
Now, Chair Wilson for the people.
Good morning, Rob Gico on behalf of Jeremy Shue. Jeremy, would you state your name for the record?
My name is Jeremy Shue. All right. And it's date and time set for 2 preliminary examinations. Are we ready to proceed?
Yes.
Yes, Your Honor. Your Honor, it's my understanding there's 3 officers involved here. I would ask that 2 of them be sequestered.
Well, Judge, there's 2 on one case and 1 on the other. So they're sequestered at the moment.
Okay. I'll order them sequestered, but an officer that's in charge of the case may remain in the courtroom to assist the prosecutor. All right. Which one? Call you for.
Jeremy.
I don't know what you're going to speak about, but if your counsel's, I think, indicating to you that you shouldn't say anything, but
I just got up here. I haven't had a chance to speak. There's a couple issues that I noticed from the records that I received, that some of the records are not.
that what?
Some of the records are not complete. And I mentioned that, and I don't know if we got the complete record. So my whole thing is, I don't know if we can go forward today because of the fact that discovery is not complete. So I think that.
Is you talking about thumb injury?
Yes.
This moment is where everything shifts from administrative confusion to legal friction. The judge openly acknowledges incomplete records, an immediate red flag in any preliminary exam. Missing records mean missing context, missing medical confirmation, missing injury detail, and missing evidence clarity. Defense jumps on this instantly. If the file isn't complete, the hearing shouldn't proceed. That's a classic strategic move. Delay, regroup, gather what's missing. But what's fascinating is Jeremy himself interjecting earlier, clearly wanting to speak, and his attorney immediately signaling he shouldn't. That's usually a sign the defendant is emotional, impulsive, or ready to offer statements that could hurt their case. This VO marks the first major tension point. Is the court even ready to proceed? Prosecution claims yes. Defense hesitates. Judge Simpson clearly wants structure, order, and a clean record before moving forward. And for the audience, this is the first clue that the events leading to the injury are not as straightforward as door closed, rib fractured. Even the medical reports are being questioned. Would you continue the hearing if the injury records weren't complete? Or would you hold off until nothing could be disputed later?
Your Honor, I did meet Mr. Shue the other day. Spoke extensively. We do have the medical records regarding the fractured rib. The other injury to the officer was a hyperextended thumb. I'm ready to proceed on that matter, Your Honor. I mean, the report says it was a hyperextended thumb, Your Honor. I'm not sure how much medical record there would be there. I explained that to Mr. Shue. I'm ready to proceed.
If there's a conflict, then I guess there's a conflict of interest between me and Mr. Kittlebaugh. And I would like to review them at my counsel.
Okay. That's denied. Is there, so I'm assuming what's alleged is one of the injuries to the officers a hyperextended thumb.
Correct.
Is there Is there medical involved? I mean, I'm not asking you. Back in the day, if I had a hyperextended thumb, I just popped it back in and kept going. So I don't know.
Judge, the report did reflect that our deputy was treated at Trinity Health. And, Ann Arbor, Mr. Killwell has all the information that we have, to my knowledge. I believe the officer can testify to what medical attention he received.
Mr. Kilwell.
Judge, this is my client. If he says he needs those medicals, Your Honor, if he wants to adjourn this matter, I'm willing to adjourn it. I'm also ready and willing to proceed, Your Honor, on this matter.
If the defense is asking for an adjournment, Judge, we don't have an objection.
Here the courtroom hits a crossroads. Defense wants more time, prosecution does not object, and the judge now must decide whether an incomplete evidentiary packet is enough reason to pause the entire proceeding. The underlying story becomes clearer. The officer's injuries, especially the fractured rib, require clear documentation to support the felony-level charge. Without solid medical proof, the court risks proceeding on shaky ground. But here's where the emotional layer kicks in. Jeremy Shu's attorney also signals a breakdown in attorney-client trust, referencing a conflict of interest with another lawyer. That's huge. When a defendant begins questioning counsel mid-hearing, judges take notice. Simpson shuts that down immediately, denied without hesitation, because switching counsel in the middle of a preliminary exam is rarely allowed unless the conflict is severe and well documented. This portion is a reminder that courtroom drama isn't just legal, it's human. You've got an injured officer, an emotional defendant, and lawyers trying to juggle procedure, fairness, and time. If you were the judge, would you push ahead or stop everything until every document is perfect?
Well, all right. That's on which case?
That's with Officer Gillette.
That is on the 141 case. 0141.
All right. Is there a reason then, if that's the case, is there a reason I can't proceed on the other case?
No, Your Honor.
Not that I know of.
All right, then what I will do on the 141 case says stay before me. Yes, no. Yeah, there's no way I'm gonna fit that in that day. Whatever. So the 141 case will be adjourned. So because, or the preliminary examination in person, this is going to delay his matter quite a bit. I think he's going anywhere to September 26th,
Your Honor,
2023, 9 a.m. in person. Yes.
on that case, my client would ask me if I would address bond, Your Honor. I believe he can be gainfully employed. He has a place to live, Your Honor. I don't believe he would be a threat to society. It seems like the jail is where he gets the most trouble. He said, I would ask the court to please consider a bond in that issue.
I'm not going to at this time. I mean,
I understand, Your Honor. He asked me,
no, I know, but I'm not going, I'm going to continue his bond. They've asked for an adjournment. You want the medical? I'm giving him that, but I'm not changing his bond because of that. And
Thank you, Your Honor.
so the bond on that matter will continue. All right, you may call your witness on the case ending in 961.
Now the case truly begins. After all the procedural turbulence, we finally meet the key witness, Sergeant, then Deputy, Merritt. This is the man whose rib was fractured during the confrontation with Jeremy Shu. The shift in tone here is dramatic. No more argument about records, delays, or counsel conflicts. Now we're entering evidence, testimony, and the heart of what actually happened inside that jail interview room. This is where the prosecution's narrative begins forming. An inmate barricaded in a room, refusing orders, blocking entry, and ultimately causing injury to a deputy. But as you'll notice, the details matter. What room was it? Was it locked? Was it barricaded? Was force justified? And most importantly, were proper procedures followed? This witness becomes the anchor of the entire case. Everything hinges on whether the injury resulted from intentional resistance by the defendant or from poor tactical decisions by the officers. And trust me, the defense is about to pull hard on the procedure violations thread.
Getting him, it would be Sergeant Merritt. Judge.
Sir, please come forward to be sworn. Ready doing it? Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat. Upon having a seat, please state and spell your name for the record.
CODFIRITT.
You may inquire.
Thank you. Mr. Merritt, how are you employed?
I'm a sergeant at Washington County Sheriff's Department Corrections Division.
All right. And back on September 29th, 2022, were you a sergeant?
No, I was still a deputy at that time.
Okay. And were you employed that day by the Washington County Sheriff's Department?
Yes, I was.
And do you recall if you were working?
Yes, I was.
At about 11:14 a.m. on September 29th, 2022, did something happen at the jail?
Yeah.
Okay. And I jumped ahead of myself. As a corrections officer, do you typically work at the Washington County Jail?
Yes, sir.
Where's that located?
2201 Holiday Gross.
That in this, and that is in the Washington County, Michigan?
Yes, sir.
All right. So at 11:15 a.m. that day, did something happen that brings you to court today?
Yes, sir.
What was that?
An inmate was barricaded in an interview room,
Okay.
a tablet, I had internet access. I was told we need to get in there and get that tablet back.
And who was that inmate?
Mr. Shue, Eric Shue.
Is he in the courtroom today?
Yes,
Can you point him out and describe what he's wearing for us, please?
right over here in an orange jumpsuit.
Thank you. Ask record reflect ID.
Record show shall reflect without objection.
Thank you. So you were given orders to retrieve this tablet,
Yes, I was.
and how did you attempt to retrieve the tablet?
Yes.
How'd you do that?
First, I attempted to have a conversation with him multiple times to see if he would give me the tablet back. I was told he would not. He would not open the door at that time.
Who told you that?
Mr. Shue gave me the direct verbal. He would not open the door. He would not open that door for us.
Okay. At some point, was there an opportunity you saw to try to open the door forcefully?
Yes,
And is that something that you have to do from time to time with inmates?
yes, sir.
All right. And did you take action to try to forcefully open the door?
Yes, sir.
How did you do that?
He adjusted in the chair. My key was already locked. I keyed the door to open it, and as he adjusted, I pushed the door open.
Okay. And how far did you get the door open?
Approximately 12 to 18 inches.
Were you able to get into the cell at that time?
The interview room, yes.
Or interview room, I'm sorry.
Yes.
And how far into that interview room did you get?
I got about half my body in.
And then what happened?
The door shut on me.
How did the door shut on you?
From pressure from Mr. Shue pushing back on the other side.
Did you see him do this?
Yes.
Okay, how was he pushing back?
He had his knees propped up on the door. He was sitting in a gray plastic chair. Behind that chair was a round table that was braced up against the wall.
And now, did anything happen to you when this door got closed on you?
I sixth rib.
Okay, how did you do that?
Between the door pushing against me and the door frame. Just what he did.
So, okay, so you got stuck.
Yeah,
You got stuck
between the door and the door frame.
All right. Did you have to go to the hospital for that?
Yes, I did go to the hospital.
And is that where you found out that you had a broken rib?
Yes, sir.
What were you wearing that day?
Uniform.
Basically what you're wearing today? Okay. And did you otherwise make yourself known that you're one of the deputies at the jail or corrections officers?
What do you mean by that?
Did you tell them or?
Uniform, you knew who I was.
Okay. Did you have some sort of rapport with Mr. Shue as best you could?
Yes.
All right. Thank you. Nothing further.
Cross-examination.
Cross-examination begins, and this is where cracks begin to appear. Defense counsel immediately targets procedure, specifically the cell extraction process. Why? Because if officers deviated from accepted safety protocols, the responsibility for the injury could shift away from Jeremy and onto the officers themselves. Notice how the witness acknowledges that they attempted de-escalation, but when that didn't work, they forced the door. Yet he also admits he wasn't wearing protective gear. He knew the inmate had access to the outside world through the tablet. He was aware other officers were pushing on the opposite side of the door. This opens a major line of questioning. Did the officer knowingly place himself in a dangerous position? Was this truly combative, or was it a standoff that escalated due to tactical missteps? Defense is building an argument that the rib fracture wasn't caused intentionally by Jeremy but resulted from how the officers tried to enter the room. What do you think? Should an officer attempt entry without protective gear when facing an uncooperative inmate?
Officer Merritt, is there a procedure for cell extraction? And what is that procedure?
We attempted to de-escalate that situation before having to use force. If that's not progressing into a manner where forces or it's not leading up to not force being used, then force would be called forth on that point.
You used the word "we." Were there more than one officers there?
Yes,
Okay. And as part of the cell extraction procedure, is that you wear some kind of protective clothing?
depending on depending on the extraction.
Okay. This time,
If it's combative extraction, yes, we would.
okay. Were you wearing that?
No, I was not.
Okay. Would you consider this a bad extraction?
Combative extraction?
I'm sorry, combative.
No, I would not.
Okay. Tell me what excuse me. Tell me what Jeremy was doing at the time.
He was sitting in a gray chair, had a tablet he was typing on, and had his legs pressed up against the door.
So basically he wasn't letting you in the door,
No, he wasn't letting me in the door.
and you tried to talk him,
Yep.
and he still refused.
Yes, sir.
Wouldn't that be considered a combative?
He still wasn't displaying force. He wasn't threatening to harm me.
Okay, so, but his feet were against the door, preventing you from getting in the door. And again, I don't know your procedures and I'm not criticizing it, but when, in hindsight, wouldn't it have been better to wear some type of protective vest that may have prevented this rib fracture?
We also have to take time into consideration in that event because he has something that has access to the outside world. He has the internet right there. So getting that device, there wasn't time for that.
Okay,
That was a call that they made to open the door.
was that your call to
No,
make?
it was not my call.
Who made the call?
The duty sergeant at the time, Sergeant Holman.
Holman? And did you want to proceed with this charge?
Objection, relevance.
Sustained.
All right, and so you're trying to push into the door, correct? Are there two or three officers behind you pushing on you?
There was an officer to push on the other side of the door, on one side of the door with me. Yes.
Okay, so it's not only you pushing inside the door, it's officers behind you pushing you, correct? Is that a fair statement?
There's an officer pushing with me. Yes.
Okay, so they were using force to push you through the door, correct?
No, he was not pushing on me. He was pushing the door.
He was pushing the door?
Yes.
Okay, and that pushing opened the door somewhat?
Yes, sir.
Okay, and you, was there any concern on your part when you just stuck half of your body in the door?
Not at that point, no.
But the door then closed on you, correct? And what kind of upper body were you wearing that day?
The uniform.
Just a uniform?
No vest, just the uniform.
Okay, and so how long was that door pressed against your chest or your side?
I don't honestly know how long it was. I don't think it was very long.
Did you know when your rib was fractured, did you know at that time that that's what happened?
No.
Okay, so you didn't feel any pain?
Right when it happened, no, sir.
Okay, so eventually the door was open, correct?
Yes, sir.
And then you even talked to Jeremy afterwards?
Yes, sir.
And when is it when you knew that you had a fractured rib?
After going and conducting an encounter, he walking back into the body.
This section reveals something crucial. Despite the physical struggle, Sergeant Merritt did not immediately realize he had fractured a rib. That detail matters legally. Why? Because intentional injury requires evidence of both cause and awareness of harm. The officer didn't feel sharp pain in the moment, he didn't collapse, and he even continued interacting with Jeremy afterward. Defense uses this subtly. If the injury wasn't apparent, maybe it wasn't a violent act but a pressured, accidental movement during a chaotic door struggle. However, prosecution will argue the opposite. Lack of immediate pain does not negate the fact that Jeremy actively obstructed entry and applied enough counterforce to close the door on an officer's torso. Legally, the question is not, did Jeremy want to break his rib, but did his intentional resistance cause physical harm? Moments like these remind viewers of how complex use of force incidents are. People imagine dramatic injuries, but many occur exactly like this: fast, unnoticed, then diagnosed hours later.
Okay, and you had to get medical treatment for that?
Yes, sir.
And it was confirmed that you had a fractured rib?
Yes, sir.
Did you have to take time off for work?
I did take a couple days off of work, yes.
Okay, and is there any lasting injury or anything?
No, not really.
Okay. May I have one moment with my client?
Do you want me to say yes? It's good to talk to me. I can't.
You might want to mute the microphone in front of you.
Yes, please. Is it possible that we can?
No, they're going to stay right there because you don't know how to act sometimes.
Yes, sir.
Did you want the microphone muted? Because it's not. You're going to have to do it yourself. I don't do that. It's got to be green. You got to hold it down. Thank you.
Jeremy, okay, tell me.
Sir, were the other officers ordered out of the cell once the situation was at hand?
Yes.
But you stayed?
I stayed and Sergeant Holmes stayed.
Okay, and what was the purpose of staying?
Just stay behind.
Yeah, I assume you stayed in the same room with Jeremy?
Yeah, in your room.
And-
Stood by with Sergeant Holmes.
Did you discuss anything with him or talk to him?
He was just emotional. And he just asked if he could have a minute.
Okay, and after that, did he give you any problems after that? Okay, is there is there a reason why you stayed in the room that after that situation? I mean, what was the purpose of staying in the room?
I was told to stay there by the sergeant.
Okay. Excuse me, Your Honor. Your report is, if you know this, your report is the only report that that describes your injury.
Okay.
Did any of the other officers know you had been injured at the time?
This testimony becomes pivotal. The officer confirms no one knew he was injured at the scene. This plays heavily into the defense's argument that the event wasn't the violent assault the prosecution portrays, but rather an operational mishap. If no officer observed signs of injury, no distress, no immediate reaction, then the argument for an intentional or forceful attack weakens. But here's the prosecution's lifeline. The defendant's actions, not the officer's perception of injury, determine criminal liability. Under Michigan law, resisting a lawful command that results in bodily harm does not require conscious intent to injure. Defense must now convince the court that the officer's tactical choices, not Jeremy's resistance, caused the rib fracture. This is where the audience should ask, is resisting with feet braced against a door enough to shift responsibility? Or are officers inherently placed at risk when forced to retrieve property from a non-compliant inmate?
Not to my knowledge, no.
Okay, all right, thank you. I have no further questions.
Any redirect?
Mr. Kilowald asked about your injuries. You did have to go to the hospital,
Yes, sir.
and you did receive a prescription for some medication for your injuries. Thank you. Nothing further.
All right. You may step down. Thank you, sir.
May I have a follow-up question? I'm just curious. When you went to the hospital, how long were you at the hospital for?
I didn't get back to the jail till approximately 2,300 hours.
And just very briefly, what kind of medical treatment was there any medical treatment they could give you for a fractured rib or?
They gave me some medication and then just rest.
Okay, and so you didn't spend an overnight or anything like that? All right, and how long do you think you were at the hospital?
6 to 7 hours.
All right, thank you. No further questions.
Thank you.
The courtroom transitions from testimony to legal argument, and this is where both sides interpret the same facts in dramatically different ways. Defense insists the situation qualified as a combative extraction, and therefore officers should have worn protective gear, implying negligence. They argue that policy violations created the injury, not the defendant's resistance. Prosecution counters with a simple but powerful argument. If Jeremy had complied with orders, none of this would have occurred. The officers were lawfully retrieving state property. Jeremy actively blocked the door. Jeremy refused commands. Jeremy caused the chain reaction. Judge Simpson listens carefully here because this is the heart of the case. Was the officer enforcing the law or acting recklessly? This section highlights how courtroom battles aren't about what happened. They're about what legally matters.
Thank you. Nothing further.
You may step down now. Thank you, sir. Any additional witnesses for the people?
No.
Any witnesses for the defense?
No, Your Honor.
Do I have a motion?
Find over count one.
Any response?
Judge, I have to argue on behalf of my client that you heard that there's a procedure for cell extraction. With all due respect to the officer, if this was a combative situation, I don't know what would be a combative situation if this wasn't. If proper gear had been worn, this injury may or may not have occurred. And again, though, I don't want to say there was violation of cell extraction, but it appears though that that's what it was, Your Honor.
Hold on. That's your argument?
So far, yes.
Because if he had not put his feet against the door and blocked coming in or had complied with the officer's order, there's no need even for any type of cell extraction, combative or not. Right?
Correct.
Okay, go ahead with your argument.
Well, I'll just end it by saying I think there was a violation of policy as to cell extraction that caused the injury, Your Honor.
Okay.
Thank you. I'm asking the matter to be dismissed.
Your Honor, may I speak to Mr. Kilgore?
Can you what?
Go ahead.
And no further arguments.
All right.
This is the moment Judge Simpson issues his decision, and he does so with absolute clarity. He rejects the defense's implication that officer actions caused the injury. He underscores that the defendant's noncompliance triggered the entire escalation. He emphasizes that retrieving state property from an inmate is a lawful duty, and most importantly, he finds that the injury resulted from Jeremy's resistance, not officer misconduct. Judges rarely speak this definitively unless they are certain the record supports them. Simpson makes it clear, nothing the sergeant did crossed legal lines, but the defendant's actions did. The bind over for trial is granted. That means the prosecution met its burden. Jeremy will face the felony charge in a higher court. This is the turning point for the case. Everything now moves to pre-trial in front of another judge.
In this matter, what is very clear regarding the particular elements of the offense is that, first of all, there's not an issue as to the injury being caused to the sergeant. Also, that he was acting in lawful duties, asked to take something from the defendant. The defendant did not comply with that, attempted to get it, and properly so. He went into the unit. It is the action, so that this record is very clear. It is not any of the actions of the sergeant in terms of what he did to have this defendant comply with an order. Everything that started down that path was caused from this defendant and the actions that he took, ultimately causing injury to the sergeant. So for those reasons, and examining the entire record and testimony, the court would find that the people have sustained their burden and would bind the defendant over to stand charges on resisting and obstructing an officer causing injury.
Your Honor, with respect to the information waived its reading, my client would stand mute.
Defendant having waived reading, standing mute, the court will enter a not guilty plea. Pre-trial in this matter will be
October 4th at 1:30, Judge Conlon.
October 4th, 2023, 1:30 before Judge Conlon. Bond on this matter will continue. Thank you.
Get through today's hearing. Wait, officer, hold on a sec.
What's wrong?
It's on the other case.
Oh, okay, fine. Thank you, Your Honor.
Thank you. See you in a month and a half.
Pardon me? I'd like to sign one. Probably some other attorney will be doing it, but I.
Nope, you're stuck.
Thanks, Judge. Appreciate it.
Just now, I'm just saying. I think you two get along fabulously.
All right.
Mr. Kilowald, and I mean this with all due respect to you, another fine job you've done.
Thanks, Judge. I really appreciate it.
You're welcome.
I'll tell the grievance committee that.
Okay, well. Sometimes we just do what we can, right?
This case wraps with a clear and decisive outcome. Judge Simpson binds Jeremy Shue over for trial on the charge of resisting and obstructing an officer causing injury, despite defense arguments about procedure violations, protective gear, and extraction protocol. The judge determined that none of those factors legally outweighed the core issue: Jeremy's refusal to comply with lawful commands and his intentional physical resistance that directly resulted in the sergeant's injury. From a broader perspective, this case highlights how small moments inside a correctional facility can escalate fast. A tablet, a barricaded door, a refusal to cooperate, each decision creates a ripple effect. For officers, it becomes a safety hazard. For inmates, it becomes a felony. The legal system must sift through conflicting narratives, incomplete records, emotional testimony, and procedural critiques to determine responsibility. Here, the court concluded Jeremy's actions crossed the legal threshold, and the case now moves forward to trial. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.